All right, everyone. Welcome to Fitness Program Management from Georgia State University's Kinesiology Health Department, bringing you legal issues, something that, no question about it, in this whole semester leading up to this point, we have discussed plenty of examples and case scenarios involving legal issues. In different types of legal services plans available, you see that there's organizational, transactional, litigation. What does that mean? Basically, if you can think of all of our previous COVID-19 classes where we met in class, we always started the class by watching a brief 2 to 3 minute video, and it usually involved some type of problem or issue that resulted up into litigation or some type of lawsuit. And I challenge you to think about, in fact, any videos that we watched at the start of class that didn't result in this type of effect. And the reason is because this is a pretty big issue. Let's face it, any type of situation that is involved in any of those situational assignments that we worked on, you really have to be prepared, and including, by the way, all of you as classmates shared with your peers different types of stories and examples too. But as we know, fitness centers are not exempt from that. We have to be able to prepare and defend ourselves no matter what side of the table, so to speak, that we're on. Are we behind the desk of a front desk working as a staff or as a manager, or are we coming in as a consumer, as a possible member? Basically figuring out in this, again, fitness industry, the legal services and legal issues play a big role in any event. So the first step in finding legal representation, you have to figure out what type of business that you're running. We've talked and discussed extensively about the different types of fitness center, in terms of clinical, community, corporate, and commercial gyms. And so they have to figure out, all of these different types of meeting with attorneys for legal consultation, figuring out what types of fees that they need to put themselves on with their attorney. And also, there's plenty of areas of legal risks in fitness businesses. Again, going back to the examples of starting up your own business or starting up your own service that you're going to have and provide. Are you protected? When we talk about contracts, they can be written or verbal. Is it a good idea to do so? We'll take a look a little bit about that. Torts and civil liability, the word torts basically in law means any type of wrongdoing. So anytime you're talking about in civil litigation, was there wrongdoing such as negligence, unintentionally or intentional? So we'll take a look at that when we break a little further into torts. And of course, employee and personnel issues, which, as I shared, we have talked extensively about that in previous examples. Now, first, let's go into contracts here for a minute. When we talk about contracts, there are types of different agreements. For example, if it's an agreement that is under a certain amount of dollar value, most likely you might not be interested in having a written agreement or a written contract, or if it's any of these examples here, going into business with a lot of money and resources at stake, or if you, let's just use an example of when you're purchasing a big expense like a car or a house. You have to figure out everything on paper that you would work over with your attorney, and they would read it over to make sure that it's in everyone's best interest and that it's 100% understandable on all sides. And so again, all parties being what they say, no duress, misrepresentation, fraud, or incapacity. And anything that, again, that gives you some examples as far as contracts that must be in writing. Here are some of those examples we just discussed. I guess they tell you the sale of personal property over $500. That's a good, estimate of a dollar value that you can give to, asking yourself, does this need to be written down, legally or not? And you just work around that. And same thing with membership agreements. Those are contracts. When a member comes in to join a fitness club, they are entering into a written contract. And again, the contract terms should be such that everybody agrees upon it, or the member in that case should not sign the contract, or the gym should change the wording if it's not correct in terms of what are the expectations and agreements on both sides. Different types of basic membership contract terms. This is kind of getting all the T's crossed and the I's dotted, basically getting all the ducks in a row. Do we have everything understandable on all sides? What are the different types of information that member is representing, and then vice versa, the organization, what do they promise in terms of delivering and their services that they're going to be rendered to. And it's a mutual respect, pretty much, and no different than any other type of if you're joining a club. Vendor contracts is another thing that should not be forgotten about, because anytime there is a gym or health club that works with a vendor, and I'll give you a great example. Here are some, pro shop, food, beverage, etc. And you also talk about, as it gets to the end there, health and beauty services, personal trainers, massage therapy, anything that, for the most part, when they say that vendor word, means independent contractor. That's not an employee of the facility. So in most states, employment is what they call, quote, at will, basically meaning it's a right to fire and a right to work state. So again, the employer can terminate the employee without any notice or reason, as it gives you. But that can get tricky. We've seen different scenarios, and we've discussed that previously in our situational assignments and case scenarios in class. So you've seen some of those. The handbook, what does the handbook say? The importance of a handbook. Your teams right now are creating an employee handbook for your presentation, and why is that needed? Why would the employee need to know what's involved in not only their job description, but also what the disciplinary action and behavior expectations and termination policies and such. And also non-compete clause, an interesting one there for sure. Even though there may be a non-compete clause in place, those don't hold up all the time. Keep in mind that it's obviously up to the direction of a judge or any person to look at that and see if that is a fair clause. Give you an example. If a personal trainer breaks away from a fitness center, and that fitness center in the contract says, well, you cannot train other clients here, within the parameters of, since we're in the city of Atlanta, you can't train in Atlanta. Most judges are probably going to look at that and probably throw that out, I would guarantee you, because it's just unreasonable. Even if the trainer in that case, say, signed that contract. So just keep that in mind. But they give you some good examples here. Here you go with the aerobic instructors and other types of independent contractors that there are. So these are basically important items that show you how are they defined in terms of the organization. They're not employee. They're not going to have a W-2, basically distributed during tax time. And for the most part, usually they don't get any types of benefits or paid time off, etc. But we've talked about this before as well in class, that they certainly have a little bit more scrutiny from the IRS and from also in our case the Georgia Department of Revenue when it comes tax time. And other items too here, just basically saying that, what does an independent contractor mean in legal terms for any types of, in our case, we're talking about fitness centers. And this is usually what, some of the benefits that they may have, that they'll basically be their own boss. They'll make their own schedule. They'll work when they want to. They'll take off time if they want to do that. And there are parameters, though, and agreements for the most part between independent contractors and the organizations. For example, the organization is going to expect that independent contractor to dress professionally. They may not allow piercings or certain tattoos, etc., as far as professionalism is concerned. When we talk and switch directions here about torts and civil liability, again, basically meaning what type of wrongdoing happened. In this case, was there a failure to observe a duty of care? Was there a responsibility not to infringe on another's rights, either intentionally or carelessly causing harm or injury? What type of harm was done? And here's when it talks about tort law. This is important in terms of it's a civil law, basically not criminal law. So it's not like somebody who breaks a law in this case is not going to go to prison or have to serve time for this. It's usually some type of monetary outcome that they may have to compensate others for. They give you some examples here. So again, we've looked at some of the videos prior to class in all of the classes that we've met in up to this point that probably gave you just good examples of these that you see here on this screen. And tort liability is an existence of a legal duty. And in other words, you'll see the words duty of care a lot of times in legal issues. And again, it's broken when there's a breach to that duty. What is a duty of care? Well, here you go. So in most cases for an employee handbook, when they bring someone on, you're going to be seeing any types of wording that looks just like this. Now, keep in mind, you remember when we talked about child abuse clearance, criminal background checks, those should all be already intact in accordance to when we're talking about duty of care. The different categories of torts. First of all, negligence. Basically, was this done unintentionally? And meaning, it wasn't done with the intent or on purpose of somebody hurting themselves or getting injured, let's say. And that is definitely up to liability. That's why all the more reason we've talked previously about the importance of holding liability insurance at the very least. I've strongly warned you that if you do go on to become an independent contractor or have your own business, please do not neglect that. That should be one of the very first steps in building your business, because think of liability insurance as a barrier of protection. And so when you get to that point, you'll understand, it's no different than for the analogy. You're driving a car, you need car insurance. Not that you should have a choice to have car insurance, but you should have it. You have a house, make sure you get property insurance. And same case here. Companies, generally speaking, if you're an employee of theirs, will carry insurance on you. What does negligence mean? Negligence basically meaning that something wasn't done reasonably or safely. Now, in the differences of compensation, if it's what they call comparative negligence, then the person who gets injured, let's say, would receive some type of monetary compensation. They wouldn't get it if it was contributory. So basically, when they're looking at, well, what happened? What if, let's say, for the example of a person who knows that the treadmill has been rattling and making some strange noises, and the staff has already suggested, don't get on that treadmill. We're in the process of submitting that for repairs. But the member disregards what they say and gets on that treadmill and bam, falls down and hurts themselves, twists their ankle. They want to turn around and sue that gym. Well, again, how much responsibility should there be percentage-wise? So that's something to ask. Different categories of what they call torts. So we have intentional torts here. This is where something may have done where it was on purpose, and there are very much strict liability torts. So again, if something happened, this example here that it gives you an injury from the manufacturing of an unsafe product. That goes back to our example we just talked about. What if a treadmill had some problem that it wasn't covered by warranty and that played a part in hurting somebody? And then also, again, it says up here at the top the legal status of guests, members, and participants. So there is a responsibility not only for ethics or morals we're talking about, but just out of again, Good Samaritan nature, I guess, just basically, if you see something, please report it. That's just the right thing to do for all cases, and facility dangers as well. If you see water on the floor and somebody might slip and fall, if you see something that's wrongdoing in the act, say that a member is committing theft and they don't see you, that you're watching them, reporting that. And again, there's just endless different types of dangers listed here in the facility that it gives you examples of. Employee negligence too. If an employee, it is their duty and their duty of care when members are in there to ensure safety, that they're monitoring. Great example always used here is your typical lifeguard in a swimming pool. That's their number one objective. A lifeguard's number one highest priority is to ensure that they're monitoring that swimming pool and watching every single person, because they want to make sure that everybody is safe. An employee handbook versus a personnel policy handbook. Some of these slides are going to be a little bit repetitive here that we've seen in the past. So just keep in mind, we're getting closer to your team project here as we're nearing the end of the semester. So this is a good slide to come back and take a look at and find out how does this look like for your team project. At this point, I would hope to think that all the teams have pretty much seen and dealt with these last several slides here in terms of what that looks like for your group project. We know about the Americans with Disabilities Act. We know about the Drug-Free Workplace Act. And again, I think that I would like to encourage that with the individual site paper, how much did that play a role too, these last several slides here, in terms of when you visited your sites? Did you notice that they had the OSHA posters? Where were the break rooms designated? The staff, were they all cognizant of what is appropriate and what is considered, against good nature, good taste, policy against harassment? We've seen this plenty of times. So again, I know that's a long PowerPoint slide, but the legal issues are endless. Anything that you could possibly think of. Going back to the situational assignments we talked about, again, a lot of critical thinking is very important, because sometimes you have to think on your toes. You just never know when something can happen. And even if it's not black and white in your handbook and you just have to make a decision right then and there, I've mentioned before, it's always best to find out whoever's in charge, whether it's a manager on duty or the manager themselves, or if you're the person that has to make that decision, you just have to go with the best intentions. And that's, again, where we've talked about the Good Samaritan law too. That would protect you if you had to make some type of first aid or life or death situation response too. So in any event, it's always good, wrapping this up here to get back to what we started with in this PowerPoint, fitness centers, operators, managers, anybody who's in a leadership role and running their own business, let's say, or an independent contractor, they have to have all bases covered and figure out what type of business am I in, what type of legal representation must I carry, and if this happens, how are we going to prepare ourselves? So basically, that's pretty much how they can best deal with any types of scenarios. And that's again, my belief why mock role-playing and why critically thinking about things that can happen are so vital and crucial and important. Just like the ACSM textbook that we're using, go back and refer to that, and it tells you about the important policies to adhere by. That's it for today's lesson plan, everybody. Thank you very much, and I hope you have a wonderful day.